Good afternoon, everyone. Welcome to part 2 of Professional Engineering Ethics, the Rules of Professional Conduct for Indiana, Wisconsin, and Illinois PEs. Our speakers today are Kevin Cito and Brian Zieg from Hinshaw and Culbertson LLP. Just a reminder, I'm going to be dropping the quiz and handouts in your toolbar on your screen under handouts, and then I will pop the link to the quiz in the chat. I will also send an email after the webinar so that you have links for both. If you have any questions throughout the presentation, just pop them in the question box and I will get them to Kevin and Brian at the end. So with that, I'm going to hand it over to Kevin and Brian.
Okay, well, thank you very much, Claire. Brian and I have the great privilege of addressing you today, and it's always been a pleasure to do so. Ethics are obviously an important thing, and it's not just a required course in Indiana and Wisconsin. It's important for Illinois engineers as well. Lots of terrible things can happen when an engineer finds herself in ethical hot water. And so our goal remains to help you out along the way. We don't end with our assistance just today. Brian and I or my other colleagues would be just as happy too if you have an issue that comes up to chat with you further about that. Brian has made several lectures over the years on ethics, and I have too. And we're hopeful that we can share some of our experience and knowledge with you and not just go over the same old stuff year after year or every 2 years. So one of our goals here today is to provide for you your second hour of Wisconsin ethics, building on last week's, and then as well make sure that you are covered correctly for the 1 hour of ethics of Indiana, whether it was last week or this, with the idea being that next week we will be providing the second hour of Indiana that covers statutes and rules, which is the second hour that Indiana requires for your PDHs. Okay, so for today, our goal here is that you know some of the features, you know where to find the rules if you have a question that arises in the future, and you have a sense of the purpose, because ethics are the sort of things that I don't think that the regulators are going to be parsing the words too carefully on as much as they're going to be saying, but you knew what was right. You should have known what was right. You should have known what the purpose was. And don't be getting cute with us when you try to argue that the comma was in the wrong place or something like that. So for Indiana ethics laws, we've put the website location there. Obviously, it's probably much easier to just Google Indiana Professional Engineering Ethics, but the statutory citation is there. For Illinois structural engineers and professional engineers, you'll see the Practice Act indicated there in the rules. PE ethics laws are essentially the same. I've said this in times past. I have compared word for word Rule 1380.300 with 1480.210 and have found maybe 2 words to be different over what is some 3 or 4 pages of text. So if you're licensed as one or the other, you're going to be in fine shape knowing those standards of professional conduct. Indiana has a Rule 11 that specifies in various sections its ethics rules. And here in turn is the Wisconsin ethics rules. One thing about Wisconsin that's a little different, certainly than Illinois, is their rules have architecture, landscape architecture, professional engineering, designing, and land surveying all in one document. I suppose that makes it somewhat convenient. Be that as it may, for whatever reason, Illinois still has the fragmented approach where architecture is different than PE and SE. I don't know that it's a whole lot different, but that's been the plan over the years in terms of drafting. Brian is going to jump in here in just a minute. And Brian, don't let me go too far here because I didn't count the slides here on our division, but I'll keep going here. The ethics laws in Indiana explicitly call out that you're to comply with those standards. You're subject to the exercise of discipline. And if the board finds after a hearing that there's been a violation, then you can, of course, expect suitable, disciplinary actions to follow. We're going to try to talk more about what the ethics are from a positive sense than we are the discipline in a, shall we say, negative sense. In other words, might we say that we're going to focus on the carrot and less on the stick? Indiana has this Rule 11, as I alluded to, and within Rule 11 are various sections, some 15, 16, that lays out for you the various things. I think it's fair to say that although there's a few exceptions, most of the ethics laws of all states certainly cover the main ideas. What I mean by that is work within your competence. Don't take kickbacks. Don't take bribes. I mean, do they really need to tell us that? But hold public safety as the paramount issue. Things of that sort. It's the nuances, though, that get to be a little troublesome, and that's where you're going to want to be prepared to look at rules if you suddenly find yourself swimming in those waters. Brian, how many more do I have here before I let you take over?
Just this one, and then I was going to jump in.
Okay. Well, the last thing I'll say then before I hand it over to Brian is don't ever lose track of your own common sense, because my view about it is if you're too close to the line, almost always you are. If somebody's coming to you and asking for advice about ethics, if somebody is saying, let's not tell anybody about this, we'll solve it on our own. I think that's time for you to take a pause, step back a minute, and ask yourself, wait a minute here, where are we going with this? And just because everybody does it, of course, doesn't make it right. Sounds like something your mother may have told you when you were in high school, but it still is a good point. Brian?
All right, Kevin, thanks for the introduction earlier, and to quickly bounce off something that Kevin just said. As we've given these presentations in the past, I always kind of run with a theme throughout these presentations. Perhaps two things. Number one is the idea of common sense. Kevin's absolutely right. Everybody in here is a well-educated adult, and common sense can be one of the best guideposts that you can have. Not to jump too far ahead in this presentation, but the other one is going to be public safety. At the heart of every single one of these rules is public safety, because that's what is intended to be protected by each of these rules. These rules are in place to protect the public from you, as odd as that may sound. So going on, as noted on the slide, the board can take disciplinary action for matters beyond what they've identified in the rules as ethical violations. An example of this would be failure to file your tax returns. The fact that you haven't filed tax returns has no bearing on your ability to practice as an engineer or your ethics as an engineer. Yet it's something you can be disciplined for. Same thing with child support. That's another area where, failure to file tax returns could potentially be criminal. And now, most states, obviously, failure to pay child support is the same. But nonetheless, a failure to pay child support has no bearing on your ability to practice engineering in an ethical manner. There are other things that can be considered as well for purposes of disciplinary action. But today we're going to focus on ethics and the kind of ethics rules that have been set forth that may lead potentially to a professional engineer facing discipline. One kind of caveat to that, though, is that the professional rules in Section 25 of Rule 11 especially do in fact provide that conviction for a crime may result in discipline, of course, depending on the circumstances, because there are certain crimes that you could commit that could actually affect or touch on your ethics as an engineer. Kevin will be addressing that a little bit later, so I'm not going to step on his toes too much on that point. Now, how do we analyze ethics questions? The rules, I would imagine most of you have read these rules, perhaps not necessarily carefully or attempted to commit any of this to memory, but the rules, in fact, are generally stated or very broadly stated. Now, a perfect example of this, Section 5 under the Indiana rules, and I'm going to get into this rule a little bit later in more detail, but I just want to read the language and demonstrate this point. The engineer shall undertake to perform engineering assignments only when qualified by education and experience in the specific technical field of professional engineering involved. Now, when I say broadly stated, it's because there's a lot that's kind of left open to interpretation. What does it mean to undertake to perform? What is it meant by engineering assignments? When it say only when qualified by education and experience, what specific education? How much education? What specific experience? How much experience makes somebody qualified? And then the specific technical field of professional engineering involved. How is that determined? By whom? There are a lot of open-ended questions that come out of simply reading these rules. And that's why it's important to analyze any single ethical dilemma on its facts. When I was in law school, one of the best pieces of advice that I got early on in my law school career and that I've used in my practice to date is that the facts are the law. It's easy enough to read a rule and regurgitate the rule, but the rule doesn't mean anything if it's not applied to the facts of your given circumstance. So to the bottom point on this slide, if you are seeking or giving advice on ethics, it is incredibly important that the facts of the ethical question, whatever it may be, whether it relates to conflicts, whether it relates to multiple clients, whether it relates to questions of dishonesty or reporting another engineer, the facts are essential. Now, as Kevin noted, Indiana has Rule 11, and Rule 11 is essentially 25, I think the number is 25 different sections of rules that are considered its ethics rules. They cover the ethics and professional practice of registered professional engineers. Again, for those to whom these rules in Indiana matter, it's only 7 pages long. The majority of that are kind of footnotes or citations that you can ignore. It's a pretty quick and easy read. Wisconsin has section A-E8. Interestingly, that one's narrowed down to 11 sections. But if you were to read that, you would see it pretty much covers the same issues. However, you just see things, ethical issues that are kind of consumed as subsections of a single rule, whereas Indiana tends to kind of break them out. But you're going to see the same things, i.e. questions of honesty, conflicts of interest, unauthorized practice, etc. And we're going to discuss many of the sections, whether under Indiana Rule 11 or Wisconsin rules in the following slides. The Indiana rules are very much going to provide a guide here. So let's look at the specific Rule 11 ethics rules. Section 2 of the rule indicates that each applicant is to certify on the application that the applicant has read and agrees to abide by the act and the rules of the board in force at the time. What that takes away from you is the, oh, I didn't know that was illegal, or I didn't know that was against the law. You can't play the ignorance of the law card.
Yeah, exactly. Good luck.
The fact of the matter is, when you applied, you indicated that you read them, so I hope you had. And again, it's always a good idea to refresh yourself of these rules, and it's a quick and easy read. And you also agreed to abide them. It's also a good idea, just as a quick point here, to revisit them whenever an issue arises. If an issue does arise where you may have a question as to what your responsibilities are as a licensed engineer, look up the rules. It's very quick and easy to at least get an idea of what the rule says, and then you can develop the concern from there.
I'd like to underscore that quickly. Brian makes an excellent point. Just like he was saying, you got to know the facts. I would say don't rely on some foggy recollection of what you heard on May 20, 2020, and it's November, it's next year. Look them up, check them out.
That's true, because rules do change from time to time, and they're not necessarily going to send you an email to let you know of that. Section 3 of the rules provides that the practice of engineering is a privilege as opposed to a right. What this means is that your right to practice as a professional engineer can be taken away from you, whether temporarily or permanently. It also provides, too, that in any communications with the board, particularly when a request for information is received from the board, you have an obligation to be forthright and candid. The last thing that the board is going to appreciate is you being dishonest when it comes to them asking you questions about how you're practicing underneath your license.
So Brian, let me ask you a quick question. First of all, I would say it's not unusual that the board may have an investigator call up the engineer and say, you know, a question has arisen about the blah, blah, blah project from a couple years back. Now, this isn't an FBI agent that's calling, but nonetheless, what would be your advice as someone who also practices criminal law defense when the investigator calls the engineer and wants to start talking about something that's, say 2 or 3 years in the past, something that's not necessarily, you know, tattooed on the wrist of the of the engineer, what the facts are. What would you recommend that the engineer does when he is asked by the investigator to talk about an old project? What would you say?
Sure, that's a great question, and I think it's something that is often of interest to people, even if they don't realize right now that it is of interest to them. As Kevin mentioned, I've also handled a significant amount of criminal defense as well as internal investigations. And the way those investigations usually start is with an agent, whether federal, state, or otherwise, knocking at the door and saying, "Hi, we're from the government and we're here to help." And frequently they do so, you know, at a time when somebody may be sitting down for dinner or whatever the case may be. Now, you're not necessarily going to get these that type of a knock on the door when it comes to an investigation from the Department of Professional Regulation or whatever agency it may be. That's more of a tactic in criminal investigations. But fact of the matter is, they tend to get people talking. And as Kevin mentioned, oftentimes you're talking about things that have occurred years in the past. You don't have a fresh recollection of it. You don't necessarily recall dates or events or people, and you don't have documents in front of you that can refresh your recollection or that can actually paint the picture of what it is they're looking for. Obviously, you know, the first and foremost advice would be tell them you'd like to talk to your attorney and that your attorney will be the one getting back to them. You know, any investigator, if it touches on anything that's going to relate to whether it's criminal or your right to maintain your license, whatever it's going to be, is going to allow that. Because fact of the matter is, if they say, you know, nope, I'm sorry, I'm not going to allow you to talk to your attorney, that's going to tank their investigation. So that's always the best advice. Beyond that, you know, tell them, I would have to go back and look at this file. I would have to get my mind back to where it was 3 years ago in order to accurately answer your questions. Typically what you see when it comes to departments of professional responsibility, whether it's Indiana, Illinois, Wisconsin, whatever it may be, you may get a phone call, but it's frequently going to be a letter that you receive, whether by email or in the regular mail, and it'll be a request for information, that they're going to want the information first, and then they may reach out to you, start asking you questions, but they're going to want your file on a particular project or projects, whatever it may be. But that's generally my advice. I don't know if, Kevin, you have anything you'd like to add to that.
Well, I would say I wouldn't say anything differently. I would only underscore what your points were, and that is get your facts straight in advance, because you might be caught cold and somebody is saying, did you turn in the design to the city's building department on May 1st or was it June 1st? And you're thinking, oh, I don't know. And you know, you throw out a date, and then you find out later maybe that there was something special that didn't strike you as being so important, but now you've allegedly committed yourself to a position. I know that sounds like cops and robbers. All I'm saying is take the trouble to approach one of these investigations no differently than you would an engineering problem. You don't just start designing some new electrical system on the back of an envelope, at least I hope not. Oh, maybe you do, but the point I'm getting at is you still approach it methodically, carefully, and that's the point we're trying to make. Be careful and don't blurt something out before you're ready to have your ducks in a row.
Yeah, and be careful and be thorough. Just as a quick aside here, I'm presently dealing with an issue for a licensed contractor here in Illinois. And ultimately, he came to me and said he was asked questions about this particular project at a property. He believes that the IDFPR may have the wrong property because he's got no records of that property. My instructions to him were go back and reconfirm, be absolutely thorough that you don't have anything, because if we're going to go back to the IDFPR and tell them we have no records relating to this project, we want to make absolutely certain that that is in fact the case before we go making that representation. Because the last thing we want is to have him get in trouble for misrepresenting or being dishonest with the board while they were investigating something that he otherwise did nothing wrong on. We don't want to create trouble where there isn't trouble. So it may be just kind of a common sense passing rule, but again, it's one that, you could ultimately create for yourself a situation where you're getting disciplined where, had you been thorough, been honest, been forthright, you would have, never faced discipline to begin with. So take any inquiries from the board very seriously. You don't have to be dismissive, but be honest with them. And again, if you're in a position to do so, refer them to your counsel.
All right, so let's go on then to talk about public safety. Without any doubt, whether you read it in Section 1 of the Illinois Professional Engineering Practice Act or wherever, you'll see that just as it says here in Section 4, the primary obligation of the engineer is to the public. Now, Indiana has a rule similar to Illinois that indicates that if your professional judgment is overruled concerning public health and welfare, you have to inform your employer and the proper authorities as appropriate. Who those proper authorities are may depend on the circumstance. It may be OSHA. It may even be the police, strangely enough. It may be, of course, the building code authority. The point is, you can't hold this to yourself and hope for the best that things are going to work out. Now, obviously this calls for judgment. It calls for trying to talk it through, but just don't be left holding the bag, as it were, when in hindsight, you are acknowledging that there was a problem, but you just kind of let it go, and that's just not a good thing at all. Wisconsin has a similar rule, but it's a little broader. And they're talking about misconduct means any act which jeopardizes the interest of the public. And then they go on to list some things. I would suggest to you that is a rather broad category of jeopardizing the interest of the public. And the problem is, this would tend to be a hindsight test. In other words, it seemed like the building was fine, and then there was a fire. And now what you thought might have been okay, well, obviously the fire could jeopardize the interest of the public, might even kill somebody. And now suddenly you're put under the microscope. Not good. Be careful and think ahead. And, in Illinois, we have that similar wording about public safety. It can't be overstated. And, my thought always is too, that the bigger the problem, the keener the hindsight becomes going forward in terms of putting engineers under the microscope. So, we have issues, you might say, about parsing some of the words. What does endangered mean? Who's the employer? What does all this mean? And what if you go to the engineer of record and he or she has a contrary opinion? Well, all of this needs to be talked out. Our overall point to you is don't feel like you should keep it under wraps and fail to say something, because at the end of the day, it is your license, not somebody else's license. It is your license, and it is the right thing to do without, even if you hadn't read these rules, you would know that. Let's see, Brian, is this for you here? Or I'll keep going.
No, I can jump in here. So going back to the rules, Section 4 under the Indiana rules addresses public safety, health, and welfare, as Kevin was just explaining. It provides for an objective standard. That's objective versus subjective. So it's not, was there a violation based on your own individual subjective feeling, but rather, would a reasonable professional engineer in a similar circumstance have determined that there was a failure to protect the safety, health, and welfare of the public? And of course, as noted here, hindsight is always going to be an issue. Now, one thing that I'd like to point out too is the language of these rules, and this is going to be the same no matter what state you're in. Rules, laws, statutes, they always use keywords, and those keywords can trigger certain requirements or obligations. If there is something that is mandatory, if there's a particular circumstance that mandates that you do something, you're going to see words such as shall. In Section 4, the engineer shall at all times recognize the primary obligation to protect the safety, health, and welfare of the public. That means you have no choice in the matter. Now, there are going to be other times where you'll see rules that are written where they are subjective, using words like would, could, and should. There are going to be some times where there are going to be requirements that are optional, where you'll see the word may. Now, frequently that option is given to the board as opposed to the professional engineer himself. But when I read these sections, these rules, I oftentimes in these presentations make it a point to stress those words, because when you read the word shall in any of these rules, that means you have no choice, that if X, then you have to do Y. And so, again, as I mentioned earlier, at the heart of all of these rules is the obligation to protect the safety, health, and welfare of the public. And you don't have an option one way or the other on that. You have to, at all times, recognize that that is your primary obligation. And that goes to the heart of every single one of these rules, specifically the next one, which goes to competence. Section 5 provides that the engineer shall undertake to perform engineering assignments only when qualified by education and experience in the specific technical field in which he's involved. Now, I read that one earlier, and as I made it a point to mention earlier, there are some vague terms in there, some terms that certainly need defining. If you compare that language to the similar section in Wisconsin, that provides that a professional engineer may not offer to perform nor perform services which the registrant is not qualified to perform by education or experience without retaining the services of another who is qualified. As I mentioned earlier, Wisconsin tends to take some of the rules and combine them into one more robust rule, whereas Indiana appears to have parsed them out. That is the case here with the Indiana rules. Because if you go on then to Section 6 provides that a professional engineer can, and there's one of your optional words, can accept assignments outside of her competence as long as she is practicing in her own qualifications and other phases for which she may not be qualified for are performed by, in quotes, qualified associates, consultants, or employees. Continuing on kind of this theme, as I said, these three rules here in Indiana, rules 5, 6, and 7, in other states you'll often see them combined, but Indiana has a separate rule regarding your use of your seal. And that rule provides that the engineer, again, mandatory language, shall not affix his signature or seal to any engineering plan or document that involves a subject matter in which the engineer lacks competence due to insufficient education or experience, or to any such plan or document not prepared as described in, there's a statute here, 864 IAC 1.1-7-4, which relates to pre-designed manufactured equipment. So again,
let me jump in real quick to say we'll talk about manufactured equipment next week. Go ahead.
Well, there you go, a little preview. So, real quick summary, a professional engineer cannot do work that is beyond his or her expertise, or I should say education and experience. You can accept an assignment that's beyond your education and experience, but those portions of that assignment that involve that kind of work must be done by other people who are in fact competent. And you cannot affix your signature or seal to plans or documents that are outside of your competence, your education and experience. So a quick hypothetical. If we have an Indiana registered professional engineer, we'll call him Engineer Joe, and he's working for a firm that is based in Illinois. That firm has Illinois licensed and experienced professional engineers and structural engineers in that office, and they produce a design in a field of engineering that is outside of Joe's own competence. The question is, can Joe seal the design drawings for the Indiana project? And the fact of the matter is, it's again, going back to that mandatory language that I mentioned. The engineer, that would be Engineer Joe, shall not, mandatory language, granted it's negative mandatory language, but still mandatory, shall not affix his seal to any plan or document that deals with subject matter in which he lacks competence. By this very hypothetical, Engineer Joe lacks the competence for this particular field, for this work that was done by other licensed professional engineers or structural engineers. Accordingly, he cannot, but he shall not affix his seal to those drawings.
Hold on just one second.
Sure.
I'm moving my... Suddenly, my PowerPoint does not want to react to my commands.
Oh.
I don't know what is going on here, Brian. Let me try to get control of this. There we go. Okay.
There you go.
Sorry for the
You
delay.
can go ahead one more slide. All right. So, the signature and seal certainly is relatively clearly addressed, but what about Rule 6? Again, Section 6 of the Indiana Rule 11 provides that a professional engineer can, has the option to accept an assignment that is outside of her competence as long as she practices within her own qualifications and has those other phases performed by qualified associates, consultants, or employees. So in our example, Engineer Joe had other qualified employees, other qualified associates perform the work that he was otherwise not qualified for.
Yeah, I think the key thing is, it's one thing to accept the assignment and then line up the right people, but that still doesn't give carte blanche to the opportunity for Joe, or I shouldn't say the opportunity, but Joe being requested to seal the drawings, going beyond merely accepting the assignment.
Absolutely.
Okay, let's go on from there now. Certainly another thing that's, again, probably no surprise, but the importance about being objective and truthful in all professional reports, statements, or testimony. One thing I like to underscore is that sometimes people think about doing engineering work as involving designs and specifications, that sort of thing, but reports are no different, really, in terms of that being under the full rubric of competency, truthfulness, and all that goes with that. And notice the phrase there about including all relevant and pertinent information. This is a little bit like that famous comment, telling the truth, the whole truth, and nothing but the truth. Be careful if you're in one of those situations where, whether it's the lawyer or whether it's the boss or someone else that says, tell no lies, but don't volunteer other information that we don't need you to say. That's courting disaster, in my opinion. So as I say here, I even put this in here about telling the truth. But what do you do with the lawyer who only wants his side of the truth? You got to be honest. You got to say, wait a minute, we don't think there's a problem here. But one thing, and I'm going to ask you to comment on this, Brian, is in a second. You still, as an engineer, need to work with the lawyer that's hiring you, or as the client's lawyer, because maybe the lawyer appreciates that the issues in the case are 1, 2, 3, and 4, but not 5 and 6. And so the lawyer may say, look, I'm going to ask you for your opinion about issues 1, 2, 3, and 4. And you say, well, what about 5? What about 6? And he says, that's not an issue in the case. Brian, what would you say to that?
Quite frankly, that happens all the time. Oftentimes we have lengthy discourse with our retained experts, whether they're in the design professional area or otherwise, and also oftentimes in litigation, the issues in question can be very narrow. And so while you may go in looking at a particular project or particular work done on a project or particular designs and specs and say, well, here's what I'm seeing that's wrong, the attorney may focus you and say, well, what I need is an opinion that X, Y, and Z over here was satisfactory or not satisfactory, whatever the case may be. I'm not necessarily concerned with that. That doesn't necessarily mean I don't want to know about those concerns over there, because I need to know those things as I prepare for trial, as I prepare for your deposition, whatever the case may be. But I also am not necessarily looking for that opinion. At the same time, too, what I'll also say is any attorney worth their salt isn't going to want you to make an opinion that you can't support, because that's not going to do anybody any favors. And if I'm looking for an opinion from you that you don't feel comfortable making or you feel is unsupportable for whatever reason, I want you to tell me that, because then maybe I focus on other issues, or maybe I, look at other problems, or maybe I need to approach my case from a different perspective. All things I need to know to best represent my client.
Absolutely. Well, okay, so when it comes time in Indiana here, in particular about opinions, and no different rule applies in Wisconsin, but they're looking for you to express your opinion only when you have an adequate knowledge of the facts and technical competence. Just because you have a PE license doesn't mean you're an expert in all branches of PE, at least in most circumstances. And the honest conviction of accuracy and propriety. So one of the things, thank heavens, that people appreciate is that different engineers can hold different opinions, and they hopefully are doing them with honest convictions, as opposed to allowing themselves to have their opinions be bought by the highest bidder. I'll say whatever you need, just fill it out for me and I'll sign on. I mean, that's a terrible thing, of course. But just because two engineers hold different opinions does not mean one is wrong, of course. So what about that client's lawyer? We talked about this or touched on this. Again, the lawyer may know best what the issues are, but you need to hold up your own on your ethical obligations and be prepared to say, I just can't say that. I can't tell you that water runs uphill. I can't tell you that is an engineering fact. And good lawyers should appreciate that they better hear it from you than to hear it for the first time from the opposing expert and get clobbered with that surprise.
And just to jump in here real quick, the value in anybody being an expert is their credibility. And as soon as anybody starts kind of wavering on issues that otherwise makes them not credible, the value of that expert declines significantly, particularly where if they testify, this is all public record, and any good attorney can go and find every instance in which a particular expert witness has testified. And again, the value, the inherent value in anybody holding themselves out as an expert is in their credibility, and you certainly don't want to sacrifice that.
Absolutely. And, you know, say what you want about jury trials. Brian and I would be quick to tell you that juries can spot a liar a mile away, maybe 10 miles away. It just comes right on through. So our point to you is, you know, do your homework. If you're asked to be an expert, or if you're a defendant in a case and you're being, you know, you're facing an opposing expert, you know, there's nothing ethically wrong about having different points of view, but you've got to do your homework. You got to know your facts, and you've got to be, you know, on very solid footing and go at it from there. Let's talk about public speech then. In this respect, the ethics rules are very insistent that if you're going to speak on behalf of an interested party, you have to not just identify yourself, but disclose the interested party's identity and reveal your pecuniary interest. You might not be a stockholder in the development company that wants to, for example, do a new subdivision, but just the fact that you're retained by them, you can't somehow make it look as though you're not so involved. You can't go to public planning commission meetings and things like that and act like you're just an interested citizen, when in point of fact, you've got an edge, so to speak. You're looking to get the job. You are on the job already. This is the sort of thing that the ethics rules are addressing. So I give you this hypothetical here. Ajax wants to hire Sue to be interviewed on why windmills should be allowed in Lake Michigan. That would be something. She thinks it's a great idea. You know, less pollution and kind of a why not? The lake is so big. I mean, surely we have room for some windmills out there, wind turbine kind of things. You know, what's the problem? But, you know, what does it look like though when she's talking to the press? If she's hired by Ajax Windmills, she can't hide that. If she just happens to be an interested citizen, or for example, like we see sometimes where the press or the TV media call a professor and say, Professor Jones, what do you think about the issue of windmills, wind turbines in Lake Michigan? People might assume that the professor is an honest person with no axe to grind and is just going to give an engineering opinion. But going back to this, Sue has to be careful that she's in fact identifying herself with Ajax and that she's been retained. She can't lead the press on to make it seem as though she's independent and unpaid. You know, and that she's just doing this because she just happens to be an engineer. And although I don't put it here, it also needs to be understood too that Sue needs to have done her homework and have an engineering opinion on the subject, as opposed to kind of winging it, shall we say, and thinking to herself, well, I don't know much about wind turbines, but I bet they would work, so I'll say that they'll work. That they'll work even in Lake Michigan, even though I've never seen or heard of that happening before.
All right. So I'm gonna jump back in here. Conflict of interest. I think that as weird as it may sound, that this is a section or a portion of this presentation that actually kind of intrigues me. Part of it is because it's something that I, as an attorney, have to deal with myself anytime we get a new client or anytime we get a new adversary. But I find the wording somewhat intriguing as far as the rules, especially the Indiana rules. Now, Section 12 of the Conflicts of Interest provides that the engineer shall, again, there's that mandatory word, the engineer shall conscientiously avoid, it's interesting wording, they shall conscientiously avoid conflicts of interest. But when unavoidable, the engineer shall, again, forthwith disclose the circumstances to the engineer's employer or client. Now that one raises all sorts of questions. First of all, what does it mean to conscientiously avoid conflicts of interest? I mean, I guess that means, you know, you're keeping that in present mind. You're always aware of your obligation regarding conflicts and taking steps not only to recognize conflicts, but also to avoid running into those conflicts. This rule also recognizes that some conflicts are unavoidable. What those are, they're not going to tell you. When you might recognize they're being unavoidable, the rule is not going to tell you. But when a conflict is unavoidable, the engineer shall forthwith disclose the circumstances. How fast forthwith is, I have no idea. I don't think there's a single person in the world that could narrow that down to a specific time frame. This is where you're going to get back to that reasonable engineer standard, that objective standard. Under the circumstances, what would a reasonable engineer have done? That's the stick against which you will be measured on this. And then there's, in this section 12, a requirement to disclose the circumstances to the employer or client. It doesn't say how that disclosure must be made. Technically, if you call your client up on the phone and say, hey, you need to know, I just realized that I have a conflict of interest here, and I wanted you to be aware of it, you've technically abided by the rules. However, 3 years down the line, when the Department of Professional Regulation suddenly gets wind that there may have been a conflicts of interest issue, and they come knocking at your door or requesting information, and you don't have a letter to the client disclosing that, or an email, something in writing, you're going to be relying simply on your own word that you in fact disclose that to the client. Quite frankly, the best practice is to get both parties' consent and to do so in writing. So not only are you disclosing the circumstances of the unavoidable conflict, but you're getting the consent of both parties, and you're doing both things in writing. You're disclosing the conflict in writing, so there's a record of it that you can go back to 3 years down the road if need be, and you've got a written consent from both parties saying, we're aware that there is a conflict here. We don't think it's going to affect us, so we're okay with proceeding, with this engineer on this project. Again, this is not a requirement under Section 12, but it is absolutely a best practice.
Without doubt.
There's a note on the slide. Lawyers do face conflicts issues frequently, and our conflicts requirements can tend to be different than yours. That being said, lawyers might unconsciously impose lawyer rules on engineers, but if you speak to counsel and a lawyer gives you advice on a best practice for avoiding conflicts, know that that probably arises out of that lawyer having to deal with many of these same issues on a regular basis. Happens all the time. Going on to Rule 13. Now, Rule 13 is a rule that is titled Disclosure of Conflict of Interest. And the language of this rule states that the engineer shall avoid all known conflicts. So there's no conscientious avoidance of conflicts. This one's now avoiding. And you're not just avoiding conflicts, you're avoiding all known conflicts. So it almost removes the mental state requirement here. It makes it almost a strict liability type rule. If you know of a conflict already, then you shall avoid such a conflict of interest. This one also has a disclosure requirement, as the title would indicate, and this one states that you shall, again, mandatory language, promptly inform. Promptly sounds like it might be a little bit faster than forthwith, but you shall promptly inform the engineer's employer or client of any such conflict, of any association or circumstances that are going to influence your judgment or your quality of services, which takes us all the way right back to the beginning of this, where at the heart of every single one of these rules is the public interest. Now,
Well,
go ahead, Kevin.
I was just going to say, no doubt about that. Please keep going.
Yeah, and so of course this language, requires you to promptly disclose any conflict which could influence judgment or quality of services. Now that's suggestive. Before I talked about using some suggestive words, and it may be suggestive to the engineer or to the board. Here's one that it's almost telling you, you need to analyze this. You need to evaluate this for yourself and make that determination whether or not this conflict could, not would, but could, has the potential to influence your judgment or your quality of services. It puts that obligation on you to do so. And it's, again, going to be an objective test. It's going to be the reasonable person or reasonable engineer test, as opposed to simply what was in your head at the time.
Brian, we're getting closer to the end here, so we should maybe pick up our pace a little.
I will do that. Absolutely. So Section 13, that requires the disclosure of a conflict of interest. Just always keep in mind, a test that governs lawyers, and that is avoiding the appearance of impropriety. If it looks like a duck and it smells like a duck, I guess it walks like a duck and talks like a duck. I'm mixing metaphors. It's probably a duck. Avoid the appearance of impropriety and err on the side of giving too much information. Best practice, again, provide more information rather than less. And again, document all of this. Rule 14 of the rules goes to undivided loyalty. And that involves when you're getting paid by more than one party on the same project. Again, you shall not accept compensation unless the circumstances have been fully disclosed and agreed to by all interested parties. Once again, the rule does not require that that agreement be written in writing, but I'm telling you, if you find yourself in the situation, make sure you get that agreement in writing, because the last thing you want is somebody to get upset and then down the road they're calling shenanigans on something that was otherwise completely on the up and up, but you can't demonstrate otherwise simply because it wasn't documented. I'm going to kind of blend the next two slides together, gratuities and kickbacks. In Wisconsin, they actually put these both as two subsections in the same rule. Indiana separated them out. But Rule 15 provides that an engineer shall not accept gratuities from a client's contractors or agents or other parties that deal with the contractor in connection with work for which the engineer is responsible. Now, it's possible that you may find yourself dealing with a vendor of your client who may also want to be a vendor of your engineering firms. And so that particular vendor may want to entertain you, may want to, give you some, spread at Christmas of candies and fruits and nuts. If it's not in connection with the work for which the engineer is responsible, you're probably going to be okay. But what they want to avoid is, preferential treatment to a particular contractor by an engineer on a particular project that they otherwise might not get if all things were equal. And the same thing goes to the issue in rule number 16 regarding kickbacks. It's a similar rule, but this says you can't accept anything of value, a kickback, whether it's monetary in nature or in kind, services or other products from suppliers in exchange for referring that particular supplier's project. Because what that removes is your actual judgment as far as what's the best product to use on a given project. What's going to be the safest product for the public? What's going to be in the best interest of the public? If that gets removed, then you're running askew of your ethical obligations. And keep in mind, too, that it's not simply receiving and accepting money, but the act of asking for it or soliciting it is likewise a violation. Turn it over to Kevin now.
Okay, so we're getting near the end here, but we want to cover a couple more things here about the Rule 11 in Indiana. And although we have not mentioned too much about Wisconsin, let us assure you, Wisconsin, as we've often said, has very similar language, might not have identical language, but it's certainly the same spirit of matters. Sometimes we're trying to cover some very specific points. Like, for example, Indiana spells out over 3 separate sections in Rule 11 about being a member of a public body. Don't participate when you're the PE or you're seeking that sort of work. Let's just say that if you're going to be involved with public bodies, I urge you to read sections 17, 18, and 19, just to be very careful. Don't get yourself into a situation where it's hard to back out. Okay, all of the rules, Illinois, Wisconsin, and Indiana, all talk about accurately representing your qualifications and competence. And this goes to clients, it goes to employers. Again, it's hardly a surprise from the public safety point that Brian made so strongly at the beginning. obviously, they don't want you to be signed on to take an engineering assignment that really is in which you're over your head. You just don't have the qualifications and competence, yet you've represented it as though you did. Well, obviously, this rule is not going to be, or this rule is intended to make engineers think and rethink where they stand. Now, lawyers talk about puffing, which is a word that lawyers use to, shall we say, accentuate the positive or express an opinion. You know, I'm a very experienced professional engineer, and I've worked on probably 100 different projects, and I feel like I can solve your issues. Well, that's probably acceptable. You certainly wouldn't want to say, though, that you were the engineer of record on the blah, blah, blah project if in fact you weren't. Plus, you know, nowadays with the internet, a lot of times your representations can be checked out pretty quickly anyway. You don't want your name to be used with a business venture that is engaging in fraud. But the problem is, here's my situation. A lot of times this fraud or dishonest business that is mentioned in this section 22 isn't known until later on. In other words, you thought that the business venture was on the up and up. Investors come in. 5 years later, the whole thing crashes. Maybe the original instigators no longer have any money. And now they're looking for you because you've got some money and because you've got a professional license. And lo and behold, you're finding out that you're being painted with this broad brush of fault after the fact. Brian, I know that you've had situations about this. Please comment about how people find themselves in trouble way after the fact.
Yeah, absolutely. I mean, it happens all the time, and usually it starts from the investigation stage where somebody gets wind of something going wrong, and the investigators kind of start with that lead, and as you would expect, they get other leads that take you in all different directions, and eventually one of those directions might be to you. Now, whether or not you've done anything wrong at that stage really doesn't much matter when you've got a state or federal agent who's now inquiring as to what were you doing on this particular project at this particular time, and invading your life and invading your work, and potentially viewing you as a target, right or wrong. It unfortunately happens frequently, and it's why you need to always be kind of have your head on a swivel for such circumstances.
Okay, reporting violations. This is one of the most important things of all. I always mention that they tell us that the Attorney Registration and Disciplinary Commission gets more inquiries about whether something should be reported or not. It's not so much lawyers that are directly involved in the bad conduct as much as persons who get wind of it and are concerned about their need to report. Well, okay, so what do we see? In Section 23 of Rule 11, Indiana says that the PE must report violations by others in writing and cooperate. So the point is, you've got to report them. You've got to come forward. Wisconsin has the same situation. Illinois is a little bit weaker, but the point is, it's up to you to report. And my suggestion would be that if you're going to make the report, state the facts and avoid the conclusions. Don't make the diagnosis. Stick with the facts. I saw this, he said this, that sort of thing. And then the question becomes, well, if you make the report, are you free from liability if the board decides there wasn't a violation? Maybe there was smoke, but there was never any fire. You reported the smoke, did so in good faith, but then again, maybe there's a defamation lawsuit if something follows from there. That's an important question. In Indiana, you are only off the hook if you've acted in good faith. A couple other quick ethics rules. Conviction of a crime. Brian touched on this earlier. It's really a problem. And is it a direct bearing? I can assure you they'll say it is. And they'll say if you can cut corners, whether it be failing to file tax returns, they're concerned you're going to cut corners on the next project. they see a linkage. And as we point out, I think this is obvious, but if your license is suspended in one state, do expect it to be in big trouble somewhere else. Wisconsin has a 48-hour rule that says that if you have an adverse determination about your license in other states and you're licensed in Wisconsin, you must tell them in writing within 48 hours. If you're licensed in Wisconsin and you get into trouble, start getting the book out, because you just don't want to have somebody piling on a charge. It's bad enough if they got you somehow in trouble in Indiana or Illinois. It's even worse if you didn't tell Wisconsin quickly enough. So how to resolve an ethics question here as we wrap this up for today. Seek the advice. That might be good. Our point though, and yes, this sounds like a commercial, but when you get advice from your lawyer, the advice will be confidential. What if you work at a big firm and the engineering firm has an in-house lawyer? I would suggest to you that the in-house lawyer has as her client the company, not you. Oh, it may have some overlap, but it may very well be that you always will want your lawyer, not the company's lawyer. We could spend a half hour, if not hours, talking about that subject. But the point is, getting advice from a lawyer, that's a great start. But remember whose lawyer it is, and you might be penny wise and pound foolish if you're working with the company's lawyer. And you want to get those facts and take a good look at where you stand on things. So next week, we're going to talk about Indiana statutes and rules so that you will have completed your second hour for Indiana credit. We'll talk about that, like I say, 1 week from today. Brian and I stand very much ready and hope that if you have an issue that you'll consider us when and if that problem arises. Ethics is something that people can have different points of view on, but as Brian has commented several times today, when the rule says shall, or the reverse of that, where it says the engineer may not, well, those are pretty strong rules, and you don't want to get yourself on the wrong side of those. Brian, would you like to offer some kind of closing comments just to kind of wrap up some of your thoughts?
Absolutely, and I'm going to go back to the common theme as number one, common sense, as Kevin mentioned earlier. If something doesn't feel right, pause and take a second to reflect on it, whether that reflection involves talking to a colleague, talking to an attorney, or looking at the rules. And number two, bear in mind that everything comes back to what's in the best interest of the public, or what's in the best interest of public safety. Those are kind of your two best guideposts in navigating any ethical issue that may arise in your practice.
Okay, Claire, let's ask you, do we have any questions? Brian and I cannot see the questions, and if you have any, please give those to us and we'll try to wrap this up. We appreciate people are always worried about time, and we don't want to overstay our welcome.
Yeah, we do have a few questions. As a reminder, if you do have any at this time, please put them in the question box and I can get them through. The first question is, if my professional judgment is overruled, should I discuss this with those overruling me or go directly to the employer or proper authority to report this?
Okay, I'll give the first answer and Brian can chime in. First thing is, definitely talk to the person who's overruling you. It could be there's just a simple misunderstanding. It's possible. Let us hope that that's it. If they say, no, I'm telling you, listen to me, my employee, I am telling you, this is what we're going to do, and you're licensed in Indiana or Illinois, then step two is going to the public authority. Brian, do you have anything to add, or otherwise we'll move on?
I think part of that question too also asks, should you discuss with them first or just go straight to the client? And I agree with Kevin's response that, yeah, absolutely. If somebody's overruling your judgment, talk it out with them. I mean, as Kevin mentioned earlier, engineers have differing opinions all the time, depending on the way they're viewing a certain set of circumstances and a certain set of facts. It's absolutely worthwhile to discuss with them and discuss with the client.
Okay, next question.
Our next question is, what is a quote-unquote public body?
Oh, I would say any appointed or elected body. It could range from, say, the board, the board of supervisors of a county. It could be the alderman of a city, but it might also be an appointed body like a plan commission. I would suggest to you, assume that it's to be broadly interpreted, not lesser quality. Is a condo board a public body? I don't think so. But anything.
Yeah, you see this a lot in school boards and park district boards that are hiring contractors and hiring engineering firms, and those are bodies where frequently you just have, professionals in the public that are serving as board members, whether they're attorneys or whether they're engineers, and so you get all walks of life that serve on these boards. And those are the situations where engineers can get in trouble, is if they're on a board that's making determinations on bids, and one of those bidders happens to be a firm on which you as a board member have a relationship with.
So Brian, in that respect, so you're on a 5-person board and the other people are liking you as a board member and they think you bring great wisdom and experience. And then they say, Brian, let's just hire your firm. Let's just hire your firm to do the blah, blah, blah engineering work. Is that good news or bad news in your judgment?
I think it's generally going to be bad news. I mean, number one, obviously there are typically processes in place for a public body to award contracts. And during that process, you as somebody with an interest would have an obligation to abstain from any vote that's given. But number two, it's back to that air of impropriety concern. If you're on a board that happens to hire your firm to do work, regardless of how that hiring arose, it's going to smell funny.
Agreed. Okay, Claire.
So the last question that we have is, would someone claiming they're a stable genius be considered puffing?
Brian, why don't you take that one?
Did I hear that correctly? Somebody claiming they're a stable genius?
Yes.
I think that's going to be taken for what it is.
Well, that seems to be our last one. I'd like to thank our attendees for sticking with us today. I will be sending out an email shortly, again with the files and the quiz. So that should be to you in about half an hour. I'd like to thank our presenters for such a wonderful presentation today. If you have any questions, you can go ahead and send them to myself or Kevin or Brian. I'd like to thank everybody for coming out today. Thank you again to our speakers, and have a wonderful rest of your day.
Thank you, everyone.
Thank you. Thank you.